Good afternoon, everyone. I think we're going to get started now with our Relocation and Indigenous Rights panel. I'm Barrett Ristroff. I'll be facilitating this. And I don't know if any of you ever got caught and dragged into wanting to do your own DNA test. I did. And I found out pretty much generic, vanilla white person. And my husband did his and found out that he is pretty much 100% indigenous to North America. He's a chief of an Alaska tribe up there. But as for me, this puts me in the growing category of non-indigenous people working to improve indigenous rights. And I'm sometimes a little bit sheepish about this work, especially when I'm tasked with speaking for a group that I'm not part of. I do work for my husband's tribe and other tribes in Alaska on climate change issues and relocation and self-governance. But it can be a tough line to walk, having to avoid both romanticism and paternalism about how indigenous peoples should be in the minds of those who are not. But this is a movement like any civil rights movement or like the environmental movement that needs all the supporters that it can get, including lawyers like yourselves. There's definitely a place for all of them. Today we have the privilege of hearing from 3 lawyers. We have Adam Krappel and Alfred Brownwell, and the playwright, Mary Catherine Nagel. They've been working in different ways to advance indigenous rights, which are often human rights, and which can also be environmental justice rights. So I will ask each of them to introduce themselves in their own way and brief you on what they've been working on. And then we will have a relatively longer period for discussion to share and add to all these wonderful ideas. So we will go ahead and get started with Alfred, who will kick us off with his PowerPoint presentation.
Thank you very much. This is a very emotional moment for me. 15 years ago, I was here at Tulane doing an LLM, and then graduated and went back home to Liberia and set up a public interest environmental organizations to fight for the rights of local communities, indigenous people. And it's been a long journey. It's 15 years, and I'm now back here at Tulane. Some of the same reasons that I left were the reasons that brought me back. And I'm very happy to talk about this issue, which is something that is very much, to the core of my work. We're talking about the role that communities and indigenous people play in trying to protect the planet and protect the earth. And so now the rest of us don't really understand what it is. And I think over time, especially in the last 10 or 15 years, there's been a lot of pressure, especially in the areas where those communities live, the indigenous people, because there's been this whole demand for food, fiber, and fuel. And the territories that they occupy has been the areas there's been a lot of pressure on them. And much more, that pressure is in the areas where we work in West Africa, in Liberia most specifically, where in the last 7 years, government has attracted a lot of foreign direct investment to try to address some of the issues of resource and land. And so I'm going to focus my presentation and my work around a case that I've been involved with. Actually, 2 major cases involving 2 of the world's largest palm oil corporations, which you hardly will see, but I'm sure a lot of the ingredients and materials that they are involved in producing through the supply chain, you may have implications with. And so if you went to a store and you bought a toothpaste or a cosmetic, or you went and got a chocolate, or maybe you were someone who's trying to address the issue of renewable energy and you are driving a biofuel vehicle, you may not have noticed that, in fact, the product that is informing those issues are things that have come from palm oil operations in many parts of the world, but more specifically in Southeast Asia and in Africa, where those operations are really taking away massive amount of tropical forests and destroying the home of communities and indigenous people. So I tend to focus my work on that. But first, I hope this technology is going to work with me. It's right click?
Left click, or click on next.
Because I'm struggling with this.
Nope. I'm going to go back to yours. Is that
That's okay.
this one you want? You can go
So-
backwards.
Okay, let me go backward. Let me see.
And then normally just left click. So.
Left.
There you go.
Okay.
That's it.
So I just want to make sure that when we talk about Liberia, sometimes many people may not know what it is. I remember 15 years ago, I had some students who were asking, is it a state near California? And I started laughing. I'm like, no, Liberia is a country in Africa. And so there's many things that Liberia is linked to the U.S. And most time when I go around the world speaking and talking, to folks, 2 weeks ago I was in Berkeley talking to students, and I was trying to figure out, what do you see more familiar on this slide that you think is linked to the U.S.? And so now I ask my audience, I'm like, do you see something here that you think is closer to America? Anyone can answer that question? What is familiar on this slide that you think is more? The flag. And there's only one difference, is that it's one star. So actually I'm trying to say that Liberia was founded by free slaves. So there's a strong history with the U.S. In the early 1800s. Slaves who free and went back to the continent. And they had a mission, to try to Christianize and civilize a dark continent. But that mission, of course, became history. Most of you who have followed Liberia will understand the issue of the war, the indictment, the Ebola, the first female president elected. Sorry, you're not able to do that here in the U.S., unfortunately. And then now we have a soccer star who's the president here and there. But that's just part of what it first is, but there are many other issues about Liberia that we need to talk about. It is home to one of the largest forest belts in Africa. In Africa, there are two major forest areas, the Congo Basin and the Upper Guinea Forest. And the Upper Guinea Forest in West Africa. And I always refer to it as the lungs of West and North Africa. But if you look at the map of Africa, you certainly see below the Cape there's Liberia. And the largest block of this forest, which in ancient time completely covered the entire Africa, the remaining portions in Liberia. And a lot of my work in the last 7 years has been focused in trying to protect this forest, you see. But it just looks like it is forest. And sometimes people make mistake that it's just the trees and the birds and the animals. But this is home to people who live beneath these forests. And sometimes people get to forget that it's just the trees, and it's just the birds, and it's just the animals. But people are living there. And so, like, you see what I'm saying. So if you look at that map, you see exactly what I'm talking about in terms of what it is. This is the Upper Guinea Forest. You see Liberia. I'm not sure you see where Liberia is. The map, most of you can see that. So you see where is the greenest part. So if I went back, sorry. Oh, God.
You want to go backwards?
Oh, God.
Backwards?
Technology is giving me a hard time.
Oh, you're fine. Do you want to go backwards one slide?
Yes, I want to go back to the... Okay.
Okay.
So if you see this, if you see all of North Africa, it's completely desert. And you come down, you just see the small portion of this green forest. So you can imagine if we're not struggling to protect this forest, imagine what that would be for the entire region. So when you see I refer to that portion of the forest as being the lungs, I mean this is where a lot of the oxygen for this region is being produced. And this is Liberia, this is what the map looks like. And what has started happening with this forest, like you see with the road divided, is that in the last 7 years, the government awarded almost 3 to 4 million acres of this land to major oil palm companies. And through a concession in Liberia is the land grant that is given to those companies to be able to develop the land. And with oil and in consultation with those who live on the land, and with very ridiculous provisions in the agreement as well. And like I said, the forest is like the trees, but when we did our analysis, you can figure out, for example, the concession was given, that in this concession, there are people who actually live in our towns and villages and homes of people who were being covered by this forest. And so the big question was then, who's ready to own this land? It was a big issue. The government felt that as a sovereign, they had a right to give in concessions and not to undermine the rest of the communities. And communities say, you know where, we live on this land for many years, and we actually acquire our rights to the land, through ancestral right, or people have came here. And there's a history to show that. If you saw the first slide about Liberia being funded by ex-slaves, when the ex-slaves go back to Liberia, they're actually indigenous people who they met on the ground. who were inhabiting the land. I'm sure like here in the U.S., when the elders came, there were the Native Americans who were here. So the same thing applies to Liberia. And they even did a map that clearly laid out what the territories were for the ex-slaves. But, with the concession designer, they ignored that. And the map was very clear in terms of how it described what those land areas would be. But after that period, when there was clashes, with the indigenous people among themselves. So there have been a series of conflict around land and resources in Liberia over time. I'm trying to set the scene to show that in the environment where this conflict exists and where it's going to be resolved, and the government proceed with trying to give massive amount of land, what the implications would be. And then even the Liberian Constitution was very clear in terms of what rights to land would be, and the government had misinterpreted the Constitution. So many cases we took up and said the Constitution actually gave rights for the government to give land and resources out. But the Liberian Constitution was very clear. The Constitution said only mineral resources that government had right over, and not land and natural resources. It was very clear. But the government tried to broadly interpret mineral to include land and natural resources, and on the basis of that, to be able to extinguish all pre-existing rights to award large concessions. And in Liberia, indigenous people very much know their land. They can develop their land, use map, their land, use land planning process, everything. They're very much aware of that. So they knew what their land were, and they have passed this through oral history, through the tribes over time. And so, because of this massive grab, the communities, complained of what was going on. They complained to the government, complained to different people what was going on, and then we got involved. And there were many issues when they awarded the concessions to these companies. They just did not grab the land. They destroyed farmland, they destroyed crops. Diverted creek and stream, burial ground. You see some of the slides. I haven't seen anything, in my work. My initial focus was, addressing issue of environmental pollution, working with big corporations. But when I really got involved with the land issue, it was shocking. I haven't seen any kind of abuses in terms of what land grab really is. And most times people don't understand what land grab is. But, like I keep saying, sometimes you don't need guns to kill people. The land grab is such that when it is grabbed, they are not just taking the land. It's the history, it's the culture, it's the value, it's a tradition, it's a way of life for these people. It's like livelihood. It's an entire way of being completely altered, completely transformed. And if you listen to how the indigenous people in the communities refer to the land and the forests as their supermarket, as their pharmacy, as their university, as their institution, all of that is being altered when the land is being grabbed. Especially where rest of the poor are not being involved. And so then, some of the west stuff you will see, here in this slide you will see is massive clearing of land. Just massive deforestation going on. And in fact, to the extent that the locals started referring to the companies, one of the companies was saying that be the barber, because they cleared the land in a way that they left the towns and villages just standing bare, completely naked, as they clear around that. And the government attracted this investment in the name of development and said, come and do oil palm and you're going to develop the land. But the communities who already existed on this land were carrying on a number of agricultural activities. So, for example, there's a slide that shows where people who are planted in orange orchard, the women are complaining about this. I don't have enough time to go in details. But, here you have Social Security. In indigenous communities, they depend on the land for their Social Security. So they will do some food crop, and over time they invest into cash crops. So the cash crop over time, when they get much older, is what they rely on. When they're not too strong to go and do the rigors of farming, they rely on the cash crop to feed them. So for example, there's an orange tree where the tree bears anywhere between 7 to 12 bags of oranges. And the bag of oranges is like $10. But in this case, when the companies went to the country and they took the land, they were trying to compensate the community for $6 a tree, not even the economic or the market value of what the tree would be. So it's another issue concerning that. And this is the village where, and there's a story around this, where the communities resisted that they wouldn't even move. But if you see, in the center of that, and I'll try to show the slide, you see an oil palm. It's completely surrounded. So these were the things then, of course, streams and creeks being polluted. They said they offered jobs, but that was the trade-off. They said, okay, you're not being very efficient in the use of the land. Your orange tree you plant is not very efficient. The oil palm will bring more income and will give you better jobs. So these are the jobs, especially for women. And there's a whole story about how the women had to get up, 2, 3 a.m. There are issues about, child care and other stuff that I won't talk about. And then, of course, on their own land, they were restricted. You can't, and I'm sure those organizations would know, they put trespass. You can move in the different places. And there are a lot of lawsuits. In fact, yesterday, this morning, when I come earlier, I've been talking with my lawyers back in Liberia. The communities where people were arrested for trespass and terroristic threat because they try to protect their land. So I had to work with the lawyers and the judges to try to secure bonds for them to get out of court. So it's been an issue. Burial grounds desecrated. And it got to the point where, the complaint had gone and there was nothing being done. So you see in the slides, the president, whether the communities now decided that they will proceed and to take action. So the president had gone, when they decided to ask us now to intervene and bring the cases, the president had gone to try to convince the communities not to proceed with the complaints, with the cases. And so the locals were like, well, it's been 2, 3 years, we don't agree with this, so we're going to proceed. And she threatened and she said, well, we're sorry, it's an error, but we're going to do that. And yet they were praying. And I myself, when we decided to do that, the president invited me up on the stage in that meeting, and seeing the background there, she has a chief of security and others. And actually what she was telling me was that, you're a troublemaker. And I'm going to charge you with sedition and economic sabotage, and you will not have a bill, and I'm going to send you to prison. I'm like, Madam President, I'm just a messenger. The issues here are very grave. So that day, there were over like 5,000 persons there, and I was openly being threatened. But in any case, we decided to continue on the case. So we had a number of different things to do. So as you see in the previous slide, I've already been threatened by the president. So we had to figure out how to handle this situation. Should we proceed with the domestic process through our court system? So in Liberia, almost like in the U.S., you have the circuit, I'm sure, and you have the Supreme Court. We don't have an appellate court. But given that the case has been so politicized, we're thinking that if we're taking this case to court, and we had a legal basis. Because first, what the government did was to provide unequal treatment and discrimination against customary rights. In the Liberian Constitution, customary right is fully recognized, but the government had ignored that right and signed concessions, not even declaring eminent domain to grab the land from these communities. So we intended challenging this right on constitutional basis. But the thought was that if we took the rights of over 50,000 indigenous people to the court, where the kids are already politicized, and they got bad precedent, you wouldn't be able to do anything. So the lawyers were thinking of what to do along with us. Then there's also a regional court, which is called the ECOWAS Court of Justice, which is set up by the regional countries. We're figuring what to do. And we feel that, government to government, we may not obtain the kind of relief. And then one of my young lawyers said, but these oil palm companies are part of a global certification scheme where they have certified to provide sustainable palm oil. And that scheme has set up what you call a complaint mechanism, which is a non-judicial process, where communities who are affected by the operation of these companies can be able to bring complaint. So believe that, in terms of our legal analysis, if we took them, since they really want to showcase that they are certified palm operations, we'll be able to get some action going on, versus bringing it through the court where the government will go and politicize that, and you will lose the case. So we decided to explore that. So we went for the option of the RSPO, and there were two major trends of that process. One, under the RSPO, they have what they call the principles and criteria. One of the criteria provides that any company, even where a government does not recognize the rights of indigenous communities, must obtain the free, prior, informed consent of communities. That was huge, which meant even though the government of Liberia had ignored that right, it meant the company had an obligation to abide by that, otherwise they would not have obtained that certification process. Then secondly, there was the whole issue of no deforestation, especially for high-density carbon areas. And indeed, the areas where there was general operation were hard forested areas. So we documented our process, and we filed a complaint to the RSPO. And so the initial decisions came up, and these were two companies where the stop orders were issued, and there was independent fact-finding that came to the country, and were able to do the investigation and verify the process. And indeed, they came with the finding that the case had merit, the complaint was legitimate, and that the company needed to sit down to be able to renegotiate consent and address the issue of deforestation. The two companies who were involved in these cases at different times, I'm just trying to summarize them. So one of the companies called Sanda, we decided to opt for a conversation and a negotiation, and we started that conversation. The other company, Golden Verorium, which is from Indonesia, didn't want to proceed with that and try to use the government to do more intimidation of us in the communities. And when the government found out that we had obtained this judgment through this non-judicial process, we reacted in a very different manner. Oh my God, 2 more minutes. I've not even gone to that. Oh God. So anyway, so the government reacted to the decisions. They didn't listen to us. They didn't want to negotiate. And then because they weren't listening, the communities who felt they were not getting any decision protested, and it was very bad. And then the government got the police involved in most cases, and they arrested community members. There were raped for the entire villages. People, were arrested, put in prison. One person was tortured and, died. The people fled ghost towns in the places. And of course, through the negotiation, one of the companies really felt that, to obtain consent, it means they have to change their whole investment strategy. And that was good because our plan was to be able to protect the forest. So they revised that strategy and decided that instead of taking and grabbing the land, they would have to do all grower system. And when they decided that, the government felt they were losing an investment. So the government decided that, the best of this would be to target the lawyers. And so I was involved. In 2016, October, that's why I'm here. They issued a raid and they sent in gangsters to try to ransack my office. They tried to, go after my wife and my kids. And so friends were able to help me to get out of the country to come here. But then when they didn't see me, they really went to my staff. All my lawyers had to go on the run, they go into hiding. They deployed the police, they deployed the army, they chased me out of the country, and I was here in the U.S. But as they didn't stop there, we continued fighting the case against the other company. In February this year, we got a judgment where the IRS will rule for the second company to stop. So now, 4 million acres of forest land completely protected, even though I've been out of the country. But now they're starting a whole process of criminalization and going after our community members. So we can see that we have the forest protected, that the forest is not just a forest, but there are people who live in it. And there are also linkages with, how you protect the forest and the issue of climate change and greenhouse gas emissions, because the most sustainable the forest is managed, the better it is instead of the carbon sink. And if you don't address land rights, there are other implications. And some of the implications I will draw here to what we see happening here in the U.S. I want to be very fast. It leads to conflict, right? And people have to move, and people are displaced. And so now people are surprised when they see people displaced, like, oh, we see the news, people in Africa have been displaced and moving, they're refugees. Until you see this happening to you, right? Like here in the U.S., you see people on the borders and like, where are they coming from? But nobody understands why people are coming at the border. A lot of the immigration problems that people are faced with. I have been here for a year and a half, and I've had friends. I've gone to their homes. I have seen fathers and mothers and brothers and sisters and family completely divided in this country who are a major issue like immigration. But most times people only respond to the signs and the symptoms. Nobody understands that when you start displacing people in poor countries and you have an economic that's uprooting them, that displacement starts with a trickle and a trickle and a drip, and eventually ends up at the border. When they are now here, the people start asking, why are they here? And then all kind of proposal like, we build a wall. But no war is going to stop these people from coming. They have to find a way to survive because you have altered their way of life and their livelihood. And so part of what I'm doing here in the U.S., I'm not just in addition to teaching, I'm involved in developing an initiative called the Land Tenure Security Initiative. It's an initiative that is designed to be able to measure and rank how governments are protecting the land rights of citizens. This is important because insecure land right has implications. Implications for addressing climate change, because if you don't protect the forest, who are going to destroy deforestation will lead to greenhouse gas emission. It's just an issue of conflict. It's just an issue of poverty. It has reputational risks for even the private sector that is going to be involved. When companies go, there are legacy issues, like in the case of the two companies that lost almost 4 million acres of land. Imagine what they are telling their financials and investors. If they sign a contract to be able to do oil palm on 4 million acres of land, and 15, 20 years later, they are unable to do that. There are reputational issues, there are legacy issues that need to be addressed. And why that happened? Because they were in an area where the rights to land was insecure. Thank you.
I think Alfred's talk shows very eloquently the stark difference how the people who traditionally lived off of the land value that land versus how people from outside who want to make money off of the land value it, and what happens when those outside interests prevail. I think that's a common theme that will run through some of our other talks, and maybe we can go ahead and get Mary Catherine Nagel to introduce herself and tell us about her work.
Thank you. Okay, I'm going to try to stick to 15 minutes. My name is Mary Catherine Nagel. I'm a citizen of the Cherokee Nation, which is today in Oklahoma. Can you hear me in the back? Yes? Speak up? Okay. I'm from the Cherokee Nation in Oklahoma, and I'm also a graduate of Tulane Law School in the class of 2008. So it's such a blessing to come back to Tulane Law School, and in particular this conference, which when I was at 2L I got to organize. So many thanks to Emily and to all of the students who worked on the conference. I know it's a lot of work. It took over my life when I ran the conference, so I know that you probably haven't slept much in the last month and probably haven't had much of a chance to even be a law student. So thank you for all of your work and bringing this amazing conference together. Yes. So it's a joy and an honor to come back and to follow up on the preceding presentation, which I just thank you for your work, and it's incredibly important and critical work, and I think it's something we often forget about here in the United States, although many of our indigenous communities, our tribal nations here in the United States are still fighting the same fight. And I might mess this statistic up, but some of the folks I've worked with in this field, and this is close to the right statistic, and you can probably Google this, but it's something like 80% of the world's greatest areas of biodiversity in terms of number of species per, I don't know how they measure it, per acre, are on indigenous lands, right? So that's how serious the situation is, right? You know that the 80% of those precious lands, which hold the most species you could possibly imagine, are indigenous controlled, and so there's a lot of corporate and different international world players that want to be able to access those lands, commodify what's on those lands, and sell what's on those lands and make money from that. And so therein lies the conflict. And how do we support the tribal nations who are seeking to protect those resources, perhaps that they've lived on since time immemorial? And here in the United States, the legal framework we have to allow for that process to happen is really in great conflict. And following in the footsteps of the last presentation, it's interesting, maybe for lack of a better word, to go back to one of the very first cases that had to do with indigenous rights here in the United States is Johnson v. McIntosh from 1823. So that is a Supreme Court case in 1823 where our United States Supreme Court said, okay, tribal nations, the indigenous nations that were here before Columbus got lost in 1492 and landed over here somewhere, they can't claim legal title to their land because, and if you read the case, there's just a lot of problematic language in there about how Indians are racially inferior and they're savages and they're heathens because they don't worship Christ, but also just because they're not civilized. And all those earlier points made by the court were to support the idea that they're not civilized, but they're also not civilized because they don't commercially exploit the land. And the precise words that the Supreme Court used were to leave, and I might be slightly not, I don't have it quite memorized, but it's like to leave the land in their possession, an indigenous possession, is to leave the lands a wilderness. And a wilderness was a bad word because wilderness means natural state, means in balance with nature, means not commodified, not commercially exploited, not mined or carved out, or, you know, all the trees cut down for commercial profits. So because tribal nations weren't willing to exploit the land they lived on, they could not claim legal title to it. And that's the basis for Johnson v. McIntosh. Now, that's a very problematic framework when you look at the implementation of environmental laws outside of an indigenous sovereignty framework here in the United States, because we've never counteracted that. We've never addressed it. We've never addressed the fact that we have an entire framework of property rights that stripped tribal nations of their property rights based on the idea that they didn't commercially exploit the land enough. And so that's sort of one of the arguments that I've been making in assessing the success or lack of success of the environmental movement in the 70s, which achieved a lot, right? I mean, Clean Air Act, Clean Water Act, Endangered Species Act, National Environmental Protection Act. These are tools that are critical and very important to environmental protection in the United States today. But I think what we're starting to see is that they're not enough. And Standing Rock is a great example. I mean, what happened at Standing Rock is really hard to get your mind wrapped around, because you have the Army Corps coming in and, you know, all of these legal frameworks in place. Now, of course, you know, politics always enters into it, and so obviously the elections from November of 2016 altered the course of what the administration at that point was seeking to do. And on December 4th, 2016, the Obama administration said, do an EIS. Well, the Army Corps said, we will do an EIS. And, of course, that was rescinded by the next administration that came into power in January 2017. So you can always look at it from a political framework. But if you're looking more at just the legal tools that the Standing Rock Sioux tribe had to protect their ancestral homeland from this intrusion of a pipeline that threatens to not just destroy their drinking water, but literally, and it already has, destroy numerous burials, sacred sites, places of worship that have existed for thousands of years, since time immemorial, and the whole ecology of that landscape and of that ecosystem there in their ancestral homeland. And once again, you know, this is all, everyone's trying to target getting oil from the Bakken. Well, a lot of those lands are indigenous. You've got the Fort Berthold Reservation right there, the 3 affiliated tribes. So we see that, you know, the epicenter of some of the largest oil extraction in the United States is on indigenous lands and has huge repercussions for the tribal nations up there, not just in an environmental sense, but also with these industries often comes increased rates of domestic violence, sexual assault, sex trafficking. So our Native women in North Dakota face some of the highest rates of domestic violence and sexual assault today, often in relationship to these oil and extractive industries. I don't know if you've seen the movie Wind River, but that movie certainly highlights a lot of the problems that are actually like hardcore realities for Native women living in North Dakota today, and in many other regions of the United States that face these same intrusions by industries. But going back to the point about Standing Rock, I mean, here you've got a tribe that signed treaties with the United States federal government saying these lands will be preserved for your, even though you're giving up this piece of land, you will have this land forever. And of course, we know those promises were all broken, but also the hunting and fishing rights that were guaranteed in those treaties. And we know in the United States Constitution that when a treaty is ratified by the Senate and signed by the President, it becomes the supreme law of the land. The supreme law, regardless of what the Environmental Protection Act might say or Clean Water Act, we've got something that the United States Constitution recognizes as the supreme law of the land. And so, of course, we know that no federal court really, there are a few exceptions, really upholds treaty rights. And so most often what tribes go to when they are faced with a situation like the Dakota Access Pipeline, they go to environmental laws. And when you look at the application of an environmental law here, there have been some huge victories when it comes to NEPA and getting EIS, requiring an EIS to be done. That didn't happen here. And it didn't happen. It didn't happen under NEPA. It also was a failure under the National Historic Preservation Act, which is another tool that oftentimes is used in environmental litigation. And there are many points of analysis that you could draw, but Standing Rock, when the Army Corps of Engineers filed its finding of no significant impact in July 2016, Standing Rock filed its lawsuit within a week, requesting injunctive relief to prevent the construction of the pipeline. Just about 6 weeks after filing this lawsuit, of course, and they had environmental claims. They also had National Historic Preservation Act claims and Section 106 consultation. One of the big arguments from Dakota Access was, okay, you're saying these are your ancestral homelands and you have treaty rights and blah, 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 but you're also saying you've got sacred sites and burials, but you won't tell us exactly where those sacred sites or burials are, so how do we know that that's really true? This is all just something, this is what tribes say when they get into litigation, da-da-da-da-da. And this is something that happens a lot for Indigenous communities. The tribe really hesitated, did not file anything saying this is exactly where the burials and sacred sites are, until just before Labor Day in 2016. Actually, a landowner who had given the right, and of course he's living about a mile from, he owns a big, huge ranch land about a mile from the reservation border, but right where the pipeline was going to go. So the Dakota Access Pipeline comes to this gentleman and says, we'd like to negotiate for the right-of-way to put our pipeline under your land and through your land to get to the Missouri River right there, Lake Oahe. And he said, sure, fine, go ahead and do that. And then I guess for whatever reason, had a crisis of conscience and went to the tribe and just said, I think there are some sacred sites on my land. I know my father, when he passed the land down to me, said there were Indians that were buried here, and can you send someone from the tribe to look at this? So actually it was the tribe's former tribal historic preservation officer who came to look, and this was the week before Labor Day 2016, and Tim Mentz, and he found 27 burials, 90 sites of cultural significance, sacred sites, sacred stone formations that I can't really fully explain because I'm not Lakota or Dakota, so I can't really articulate exactly their spiritual significance. But the point is that they had 27 spiritual leaders buried here. They had sacred sites, and Tim Mentz filled out an affidavit at his attorney's urging, and they filed it that Friday before Labor Day in federal court, in United States District Court in Washington, D.C. And at that point, when that was filed on that Friday, the Dakota Access Pipeline construction crew was 20 miles away. They were still west of Highway 6, and this was right by the river. So they were, by any good estimation, 2 weeks away from constructing on this particular tract of land. And at that point in time, they had never constructed on a Saturday morning. Well, after that affidavit was filed on Friday, that Saturday morning at 6 a.m., Dakota Access had a construction crew out there. And they were literally bulldozing all of those burial sites. They went straight to those burials that were identified in the Tim Mentz affidavit and destroyed them. And folks from the Sacred Stone Camp and from the camp there by the reservation and by the river walked a mile up to protest and to pray and to ask the bulldozers and to ask everyone to stop. And that's when the company brought a private security force, which we so often see, right? The corporate private security force shows up, and they had attack dogs. And the attack dogs literally attacked. And that's when Amy Goodman from Democracy Now!, you may have watched some of the footage. She was actually there, thankfully, with her camera and captured a lot of it on film. But to step back and to see that happen and to see that nothing's been done, no federal, state, no prosecution for that crime, the purposeful destruction of sacred sites. And environmental law doesn't offer, what do you do under environmental law? You can still ask for the EIS, but now those things are gone. So what's going to happen now that the EIS, of course, and then the EIS got terminated by the Trump administration, but literally those sacred sites have now been destroyed and are gone. So there is, this legal framework that we currently have in place is failing us. And I think that the larger picture too is, how does it solve climate change? And the question, I think the answer is it doesn't. And we've seen some very creative actions under the Clean Air Act, and I think under other statutes to address climate change. But when you talk about recognition and relocation, I know specifically here in Louisiana, we've got tribes that are on ground zero for losing their ancestral homeland, lands they've lived on for thousands of years. And there's no environmental law framework to really allow them to assert their inherent sovereignty to protect those lands. And I think of the lawsuit that, for instance, the village of Kivalina, a federally recognized tribe in Alaska, brought to simply ask for the monies to pay for their relocation. And they basically said, look, we understand that these, I think it was like 20 oil companies, make this many billions of dollars in profits every year from a product that we know causes climate change. There's no scientific question at this point, even, despite those guys that Exxon paid for a while. Like, now we've got, pretty much good consensus on climate change comes from greenhouse gases. Oil is a greenhouse, or well, emits a greenhouse gas when it's burned. And so they brought a lot of tort claims and some other claims in that lawsuit, but it was thrown out on standing grounds, on constitutional standing grounds. And so that's where, so we've got this whole entire environmental framework, and then on top of that, the Supreme Court decisions that interprets that framework, and that's where we get Lujan, right? The 1992 decision that creates a constitutional barrier to environmental plaintiffs. And so now climate change plaintiffs that want to bring climate change claims because of the Lujan, which was an Endangered Species Act case. But now any whether you're indigenous or not, if you're an environmental or really kind of any plaintiff nowadays, but it's had a lot of application in the environmental law context, you have to show that the defendant you've brought into court because of the fairly traceable standard is basically the only defendant that has caused your harm. So with climate change and so many contributors and so many bad actors, 2 minutes, okay, 2 minutes. This presents a whole new challenge to the current environmental law framework that we have. And so, I will say, as an attorney at a small law firm in Tulsa, Oklahoma, that really just represents tribal nations, we use the environmental tools as much as we can. I've filed numerous lawsuits on behalf of tribal nations for failure to do an EIS against the federal government, against other entities who take on those, the EA and the EIS duties. And so it's an important framework, and certainly we don't want to see it erased or go off into the distance. But what we need are new tools. We need a new statutory framework, I think, that one incorporates tribal sovereignty and recognizes that the basis for stripping tribes of their right to exercise jurisdiction and sovereignty over their lands has historically been in the United States. You aren't civilized enough to claim legal title to your land because you don't commodify it and commercially exploit it. And until we address that harmful narrative, and it's a false narrative, we're not going to have a true reckoning, because we have to envision the environmental framework that I think we need to address the challenges we now face in the United States and in the world. We have to realize that there's a value in preserving the nation that can't be monetized. And what does that mean? And people want to say, well, is it spiritual? What is it? Well, it's our survival at this point, right? I mean, it's literally our survival. We know forests are, that like absorb greenhouse gases. We know sea levels are rising. I mean, these, we can talk about access to homelands and lands and the spiritual connection to them, but literally we're now facing a reality where it's about our survival, because if we don't preserve these forests, if we don't act to address climate change and stop the expansion of oil extraction and fossil fuel burning, then, as humans, we just won't be here anymore. So that's the issues we face, and I think the framework that I would approach this work, or the perspective that I would approach this framework from. And just thank you so much for having me here to speak today, and I look forward to the question and answer period. So thank you.
I don't know if any of you were as surprised as I was about the shocking similarities between what has been going on in Western Africa and what goes on in our own country with all of our environmental laws. And now I want to bring the focus to our very own state. I'm embarrassed to say that growing up here, I did not know that we had tribes in Louisiana, and I'm very pleased to have Adam here explain a little bit about what's going on in his work.
All right, I'd like to begin by thanking Tulane for having me over, and I thank Tulane for presenting on Indian rights. It's something, as Barrett said, is rarely discussed in Louisiana, so hopefully this is the start of further discussions. And it's great to segue off of Mary Catherine talking about Dakota Access Pipeline, because that's really been happening in Louisiana for over a century now. Dakota Access Pipeline, the Standing Rock Sioux have been able to bring legal challenges because they are federally recognized. There's two types of tribes in the U.S., those that are recognized and those that are not. Federally recognized tribes have a direct government-to-government relationship with the U.S. They're sovereign nations. As such, they have the ability to bring legal claims and exert authority over their land. So under certain environmental statutes like the Clean Air Act and Clean Water Act, tribes can be treated as states. And this can have a big impact even off the reservation. For example, the Northern Cheyenne tribe in Montana had its reservation redesignated from a Class 2 site to the more restrictive Class 1 site, and this forced an off-reservation power plant to redo how it operated. In stark contrast, if you're not recognized, you don't have any rights. You can't file lawsuits. However, you do have one recourse, and you can try to seek recognition. There's basically two ways this has happened in the last 40 years. One is through legislation. Congress passed a bill, the president signs it, and you're a tribe. This happened about 6 weeks ago for 6 Virginia tribes. The other and more commonly discussed way is the federal acknowledgement process. It was created in the 1970s in response to increased interest in American Indian rights. So basically in 1975, Congress created the American Indian Policy Review Commission. And one of the aspects it studied is why some tribes have legal status and other tribes do not. What it found is to figure out why this exists is a, quote, exercise in futility. Some tribes were denied recognition on the sole basis that the BIA budget couldn't afford to take on more tribes. And this actually happened in Louisiana. So in 1930s, the Commissioner of Indian Affairs wrote a note. Before we extend any services to the Homa, remember, we provided education funds to the Coushatta. Now we have to provide them health care, housing. Let's think twice before we provide any funds to the Homa. There's no more correspondence, but the Homa were not recognized. Nothing to do with them being a tribe, simply budget. But the report specifically noted Louisiana for why recognition is so important. So as Barrett just stated, Louisiana's long-running policy is there are no Indians in the state. So into the mid-20th century, Louisiana would put Indians in mental institutions for speaking their native language. Because if you're talking Indian and there are no Indians in the state, you must be crazy. This is in a congressional report. So pursuant to stories like this, the commission recommended the creation of the federal acknowledgement process. And the BIA did that in 1978. There are 7 criteria. They've undergone a few changes, but they remain largely the same. One is the petitioning group has to be identified as an Indian entity from 1900 to present. The other is that the community must be identified as a distinct community from 1900 to present, and it must be under a common political authority. Then it must descend from a combination of tribes or a single tribe from historic times to present. The other criteria pretty much everybody meets. You have to submit a governing document. You have to prove there's no legislation barring you from recognition. And then you cannot be enrolled in other federally recognized tribes. So like 1,000 Navajo can't pull off and say we're a separate tribe. You'd have to disenroll. And the process, despite its good intentions, has been widely critiqued since its inception. The Government Accountability Office has published multiple studies calling the process in desperate need of reform. Academics have repeatedly blasted the process, and even Republican and Democratic legislatures both agree the process is, quote, broken. And what are the problems? It takes too long. Tribes usually spend over a decade in the process. Over 30 years is not uncommon. The process is also super expensive, anywhere from $250,000 to over $2 million, and most tribes simply cannot afford this. Then there's documentation issues. Of course, documentation is reasonable, but it's tricky with tribes. One reason is that Indians, pursuant to their traditional ways, didn't keep written records. So if you're living as an Indian tribe, you probably won't produce any records. The other is that even when Europeans or Americans were around, they often embraced the, quote, vanishing Indian theory, which meant that as civilization expanded, as Mary Catherine touched on briefly, the Indians would eventually disappear. Then in the South, you have the issue, you're either white or you're black. So Indians struggled to be classified in records pursuant to this. And then even if you were Indian, you often hid your identity. As I stated earlier, you could be placed in a mental institution for talking your native language. Plus, Indian kids were forcibly taken from their parents well into the 20th century. So reasons like this are why Indians often kept their identity on the down low. And then there's more sinister critiques. One is that the recognition process was actually designed to destroy tribes. It takes so long, costs so much money, and is so emotionally taxing on petitioners that it's bound to produce political fractures within the group. And this has happened multiple times, and this takes us to the outage in Charles. So full disclosure, I am Homa, there are two tribes that broke from the Homa, and it's a very testy situation, as some people in the audience will attest. So I'm just going to provide a very bird's-eye view version of the history that I think all three of the tribes can agree on. So basically, the three tribes agree that their ancestors are in Terrebonne and Lafourche Parish by the early 1800s, and they lived pretty much in isolation into the early 20th century. Then oil is discovered on their land. Now people want to come in and get the land, and they managed to do that through a few unscrupulous means. One is quitclaims. The Indians often didn't speak English, and the French they spoke would have been different too, as Dr. Crouch, who's in the audience, will attest. She helped do some research that's very vital, hopefully, to the Homa's recognition in the future. But anyway, so the French the Homa speak is different than Cajun. So the Indians don't read, they speak a different language. They think they're leasing the land, when in fact they're conveying title to the oil company for a fraction of the land's value. Then, pursuant to Louisiana law, if your parents were not married, you were an adulterous bastard well into the early 20th century. The Indians often did not go in for white marriage records. Therefore, pursuant to their traditional ways, they lost the land. Then there's also examples of force and violence being used to coerce the Indians from their land. And legally, there was not much they could do about it. So, because Terrebonne and Lafourche operated a three-way system of racial segregation. You had white sections, black sections, and Indian sections of all public things. So they weren't in a good position to have any legal rights. This only began to change in 1963, when Homa Indian Margie Nakam brought a separate but equal lawsuit and prevailed. That was to desegregate the schools. It took a while. The Indians remained stuck in Indian schools until 1969. So that's 5 years after the Civil Rights Act. Indians are still in Indian schools in Terrebonne Parish. Then in the 1970s, they start to organize formally and incorporate, then submit a letter of intent to enter the federal acknowledgement process. As soon as they do that, oil companies get interested. So surprise, surprise, when the BIA issues a proposed finding in 1994, it suggests against recognizing the Homa. It said they failed to meet three criteria. It said they couldn't prove they're a distinct community, couldn't prove political leadership over the group, and it also said they cannot prove descent from the historic Homa tribe. It did admit, however, that they can prove they're Indian. After all, you're in Indian schools until 1969. They had to give them that one. But the petition has been widely critiqued. Three chief problems. One, John Speck. He's widely regarded as the foremost expert on southeastern Indian affairs to this day. His work was vital to the recognition of the Tunica Biloxi, Gina Band of Choctaw, Porch Creek, and other tribes. He visited the Homa in 1907, said they are descendants of the historic Homa tribe. The BIA says this assertion is unfounded on the Homa, provides no reason why. He's right everywhere else except on the Homa. Another thing that's interesting, the BIA questioned whether the city of Homa is named for the Homa Indians, who have been living there for over 200 years. Seems like that would just be a slam dunk, but the BIA couldn't connect those dots. My personal favorite is there's a Homa Indian ancestor named Louis Le Sauvage. Translation, Louis the Savage, a.k.a. Louis the Indian. The BIA admits his sister has a, quote, Indian name. It admits his niece is, in fact, a documented Indian. However, it couldn't prove that Louis Le Sauvage is an Indian. It said he may have been Flemish. You guys may be aware of that big Flemish invasion of the bayous, but I'm not aware of it. But that's actually in the petition. So reasons like this are why the BIA chose not to recognize the Homa. It did throw them a lifeline, though. It said as 6 or more tribes, they may be eligible to meet the criteria. So pursuant to this, a couple tribes break away and file for federal recognition apart. Interestingly, now they claim no Homa ancestry, which is obviously a bone of contention with the Homa. But they applied for recognition and were denied for the same reasons. They cannot prove they are descended from a historic Indian tribe, cannot prove political leadership, nor can they prove they are a distinct community. And that's largely where things stand on the recognition front. But it's had a huge impact on the environment. So if they were recognized when oil was discovered on the land, there's a chance the land may have been held in trust, which would have theoretically made it more difficult for oil companies to desecrate it. No guarantee, but in theory that could have worked. It also would have gave them a voice at the table as far as levee construction. As a federally recognized tribe, they would have at least had a seat at the table. And since being denied recognition, it's still having impacts. So a burial site was discovered in the 90s on Homa land. They filed a claim under the Native American Graves Protection and Repatriation Act to say this is a sacred site, we want our ancestors' bones protected. the court dismissed it, because as a non-federally recognized tribe, you have no standing to bring a legal claim. And this is perpetual, and I guess BP best illustrates this. So the Houma live in Terrebonne and Lafourche, right on the coast, and they file a claim with BP. BP just rejects it outright. Without federal recognition, you have no standing. And this is basically the whole history of the Houma. So that brings us to the island relocation. So the BCC are named specifically in the relocation grant. They got lots of news. But the Houma are like, hold on, we live on the island too. Now there's a big fight over, are the people BCC or Houma? The Houma claim 10 of the 25, the BCC claim all 25. I don't know why nobody's wanting to actually talk to the people, but that's a whole nother story. So this goes on for about 3 months between silly meetings between the state of Louisiana and the two tribes. And eventually the state of Louisiana, going back to the lack of care for Indians in the state, says that we were unaware that more than one tribe calls the island home. It's less than a mile long, one road. They couldn't go ask before they got $50 million. So lots of bad blood results from this. And now the state, I think rightly said, everybody who lives on the island can participate in the relocation. And that's pretty much where things stand on that front to this date. Not much is publicly available. We know CSRS has been named the master planner in the relocation. We know the relocation site is in Shriever, about 40 miles north of the island. The most illuminating thing I would say is the Phase 1 data gathering report. So they actually have like 1 page in the report on the identification of the people. And they said, we talked to the people on the island, and they say everybody is related, which is obvious if you know anything about the tribes. But it said the people on the island stayed. The only difference is some people chose to stay in the Houma after it was denied recognition, and some people chose to leave and form the BCC. And that's the only difference between the two, and the leaders are causing all the problems, which I guess is often the case in politics. And with that, I shall conclude, and welcome any questions you have. Thank you very much.
Probably there's lots of questions for all of you, and I was just going to invite the other panelists to come on up and either stand behind here or drag up a chair, and you can take questions from the audience, or if anyone's feeling a little bit shy, then I might get you started. Anyone have a question to start off with? Or let me just have you warm up. We talked a lot, all of the panelists talked about this problem of the messenger not being listened to. In the situation in Liberia, here we have Alfred trying to tell the president, I'm just the messenger, this is going on. And then we have these other discussions of who has standing or who doesn't have standing, who gets to be the messenger in this. And I wonder if anyone here wants to comment on how should we structure our standing, or how could we structure our standing a little bit better, at least in the United States law?
That's tricky. I'm sure Mary Catherine could probably chime in too. But I guess aside from federal recognition, you have the big issue right now with disenrollment, which is another issue on who's Indian or not. I guess turning to international law, the general criteria are to be indigenous, you have to have an ancestral connection to the land, be a distinct community under some common political authority, and often some kind of spiritual connection. But the UN, the chief criteria they use is self-identification for indigenous, but that's problematic. Like the Boer in South Africa are claiming to be indigenous, or they did. That didn't go anywhere.
Well, a lot of that actually depends on what the tribe or the people want to put themselves up to be. It's
right.
Certainly a decision, that's why it's self-identification. Mm-hmm. So you can come and caution yeah, you're not Indian or you're not indigenous here and there. And we had a same situation in our village in Liberia where communities who came and said they were indigenous and they were questioning, well, you're not actually indigenous, but this is how they proclaim themselves to be, a common language, self-governing process, and culture and tradition and custom. So once they proclaim that, and that's what the UN Declaration on the Right of Indigenous People claims to say, and they know what that is. So once they do that, that is a self-identification process. And so others will try to find a way to, especially from the government, from the media corporation, sometimes government, we want to find a way to challenge that. But if they proclaim themselves to be so, you can find a way to address it. And I think one of the reasons why they allow that kind of flexibility is not to try to figure out, to say, well, yeah, it's a clear structural criteria on who can be indigenous and who is not indigenous. So in that way, they allow for some kind of discrimination. case, for example, where here in the U.S., the government can decide who is going to be Native American or not.
Mary Catherine, anything to add on standing?
On standing, I mean, the one thing I would say is federal recognition is a huge issue, but even if you get federal recognition, I mean, the native village of Kivalina was told, you don't have standing, and of course this was in the wake of Massachusetts v. EPA, and they said, oh, but we do because, Massachusetts claims were found to be fairly traceable to the EPA's failure to regulate greenhouse gases, under the Clean Air Act. So, if that was fairly traceable, then certainly our claims are fairly traceable too. I mean, it's even one less step removed because there's not the government defendant that's the regulator, it's the actual actor who's emitting the harmful product, right? Shouldn't that be an easier standing, fairly traceable analysis? And the Ninth Circuit said no, actually in Massachusetts v. EPA, the Supreme Court predicated its standing finding that Massachusetts has standing on this idea of special solicitude for a sovereign, that Massachusetts as a sovereign gets an easier standing analysis. I don't even really quite understand it myself, right? But it's this idea a sovereign has the inherent right to govern its lands, and I guess you don't have to prove as much to have standing under Article 3. And tribes apparently don't have that, which I think goes back to the Johnson v. McIntosh analysis and that whole problematic framework. But if we want to, substitute something better than the current standing analysis, I would just say the whole entire fairly traceable doctrine, it comes from Lujan, and Scalia, in writing Lujan in 1992, was citing a series of Justice Powell cases from the late 1970s that were a direct reaction to the environmental movement, because all of a sudden, as a result of all these environmental statutes, you had citizen suits, right? You had people bringing suit against the federal government for not regulating, for not enforcing these environmental laws. And for the conservatives on the bench, it was very alarming to see this. And so this was how they counteracted it, is, this whole idea, this doctrine, this Article 3 case or controversy doctrine, which, if you look at the actual Constitution, it says Article 3 case or controversy. That's what federal courts have jurisdiction over, is a case or controversy. It doesn't say a case or controversy where the plaintiff can show his or her injury is fairly traceable to the actions of the defendant and not a third party, not before the court. That language is entirely invented by, the justices on the Supreme Court. So, maybe we amend the Constitution to make clear that Article 3 doesn't require that claims be fairly traceable to a single defendant and not someone else who's also not before the court. But, I think it's alarming to see something be fabricated into a constitutional barrier known as standing when those words don't actually appear in the Constitution.
One thing I want to add on that, though, is this whole idea of free, prior, informed consent, in terms of how, especially in a lot of the international cases, they've already been used. Like, for example, they accuse them with the Inter-American Coast System, with the African Coast System, where the whole concept of free, prior, informed consent has really become very central. And so a lot of lawyers try to really use that concept to try to protect them. So, for example, even if there's question over whether you are self-identified as an indigenous community, even if you are a community, you have the right to free, prior, informed consent. It has become very much, which means it then gives veto power to the people of Congress who are in the way of time.
Let's try to get in some questions from the audience. Mary Louise.
Can DNA testing play a role in showing tribal connectivity?
Probably not. It might show you're Indian, but it's not going to show which tribe, and that's the whole thing. So Indian under federal law is both a racial and a political classification. So racially, it could show you have Indian DNA, but it will not show which tribal nation you descend from, which is the whole basis for federal recognition and any other federal rights. So.
There was another question over here.
Comment to Mary. I'm recalling the Yakima case with Russell Jim being here as a speaker. I'm not sure whether that was the year that you were involved with the summit or not, but it seems as though, as a non-lawyer, being in the room with Russell Jim from Yakima and his success against Hannaford is a great case study to view how to win. Because he and his leadership shut down a nuclear plant on their tribal lands in Washington State. And if there isn't a textbook on it, there should be a book on it.
That's a great point.
Not a question, but just
Sure.
throw back to a previous summit.
Yes. And there have been some victories. Yeah, I mean it's not all losses, but it's a tough field to go into. It's not for the lighthearted.
He spoke from the law of Mother Earth. It's a non-written text, and they won.
Yes, and I think you can never
Representing a group of tribes.
Yeah, you can never underestimate the power of an amazing advocate and the impact that an advocate can have on a jury or a federal judge or a panel of federal judges. You know, so I go back to the problems in the framework, the legal framework that we need to fix. But you know, there are always those amazing examples of victories, and I think you know that's what a lot of us lawyers live and breathe on, because there are so many losses. You can't get mired in the losses, or you just wouldn't be able to get out of bed in the morning. So,
You have another question?
Back to the standing issue, do you think if they had sued the permitting agency as opposed to specific defendants without clarifying, because so many people contribute to the greenhouse gas issue, do you think that would have had a different outcome?
in the Kivalina case,
Yes.
well, I'm not sure who because I mean, I guess you'd go back to the EPA for the regulations under the Clean Air Act. I mean, in terms of permits, because this was just, you know, the world's biggest 20, you know, the largest oil companies, because they're the ones who make the most profits off of their production and distribution and sales of petroleum that emits greenhouse gases. So, I mean, if you were going to go to an entity doing permits, I guess, you know, the EPA perhaps for their permits at refineries, or is that what you're thinking?
Well, I was thinking more of the offshore,
Oh.
like at that point, because, you know, in Alaska, I was just...
Well, here in this case, I mean, those oil companies have been drilling for a long time before EPA was even around, and also they're drilling all over the world beyond where EPA or a U.S. agency would have jurisdiction. But you make a really good point. I had seen a successful lawsuit in Alaska about 10 years ago where they sued the Mineral Management Service, and actually it was interesting because the indigenous people's claims won the case rather than the environmentalist claims, because both argued that the Minerals Management Service didn't do enough research in its EIS on environmental issues and subsistence issues, and actually that was an excellent case where indigenous rights won the day. They don't always, and that brings us to an interesting question, I think. We're in an environmental conference, and why are we talking about indigenous issues? Sometimes people will wonder, and I think any one of our panelists maybe could drive that point home a little bit to help us understand maybe the Hawaiian word aina, or how people are connected to the environment. Maybe Alfred, do you want to talk a little bit about that?
I always say when I talk to people and I travel around the world and I speak, and we are in this boat together. This is a boat, we are in this boat, and we are sailing together. Whether you like it or not, it's going to affect us. I try to draw a correlationship to a displacement that happened in very poor communities in one part of the world, like in Africa or in South America, and how that displacement is having implications on people who are on this side of the world. So we see the massive migration of people coming, you know, people crossing the ship to Europe, people trying to cross the border to the U.S., from a huge line, and the tension that has to matter in terms of the political process in this country, and the displacement in the conversation. And sometimes people try to draw like, okay, this is an environmental issue, and this is a human rights issue. We've seen, for example, by protecting the rights to Native Americans or indigenous communities, you are able to preserve large swaths of forests. We've seen whether it's in South America, in the Amazon, it's in the Congo Basin, or in Southeast Asia, or it's in Africa. It is the indigenous people, it's the communities who are the major managers and users of forest land. They understand the land, they understand nature. So trying to really distribute this, I don't see how that is done. They both must work together. And we have used environmental tools in our work in West Africa to protect the environment. We have also used human rights tools to protect the environment. We use environmental tools to protect human rights. So for example, one of the cases I done where we did an ESI, we managed, for example, to build an integrated issue of free, prior, informed consent. We managed to get the environmental agency to insist that part of the consideration is to make sure whether the project proponent had obtained the consent of the communities. to be able to carry on the project. That is a human right tool that they were able to use, but it was through an environmental and social impact assessment. So in this case, we're able to balance both the environment and human rights. And I'm seeing that very useful in terms of the kind of work I'm doing all the time, by trying to use both of them. So I don't see how people will try to find a way to distinguish. I know part of the divide has been of them not trying to find a way to work together. So now we're seeing, based on the recent studies, for example, how avoiding deforestation, addressing land degradation is having implications for greenhouse gas emissions. There's been a lot of studies done in empirical analysis that show those clear relationships. So by protecting rights, you're not able to protect the environment, especially the issue of whole climate change.
I don't know, Mary Catherine, anything to add to that, and I want to go to these questions.
No, I mean, that's, I think let people ask questions. Adam?
To what extent do you feel confident that the tribal governments or the indigenous governments are consistently part of the solution as opposed to part of the problem in terms of preservation and environmental protection?
Well, that's a great question. Adam asked, how confident are you that tribal governments will be a consistent part of the solution and not a part of the problem? And that's, that's part of sovereignty, right? If a nation is sovereign, if a government is sovereign over a territory, they have the right to do whatever they want. And so it doesn't, so part of recognizing tribal sovereignty is acknowledging that we as outsiders may not always agree with what that government decides to do with their land. And certainly there are some tribal governments that want more coal mining or drilling on their land, and then there are many that are opposed to it, which is, you can see that there are moments where the environmental movement aligns with tribal advocates, and then there are moments where it's opposed. And sometimes it's a situation where, like the Osage wind farm case, where, a wind energy group wants to come in and put this gigantic wind farm. Well, it's right where, like a bald eagle migration path. Okay, so to the Osage, the bald eagle is the last thing in the world you would ever do is put something up that's going to kill a bunch of bald eagles. Well, that's what this wind farm did. And so now they're trying to get it taken down. So you've got the environmentalists fighting the Osage because they want to protect the eagles, and that's of utmost importance to them. And then you have situations like, we could list the various tribes in the United States right now that are seeking more drilling and oil exploration and extractive industries on their lands. So, yes, it's true that in terms of environmental interests, those are not always going to align. And the reality is that many of our tribal nations today are very westernized, right? They have been, we are the result of colonization over hundreds of years. And then there's the sad fact, too, that our historic way of life has been completely desecrated. So what do these tribal nations do now to provide for the welfare and literally to feed their citizens in areas of like North Dakota where, your way of life for the last several thousands of years has been desecrated? So they see, okay, we live out here, there's, the current economy and form of capitalism that's been forced onto us doesn't lend itself to job creation on our lands, but if we let this oil company come in and drill, then that's going to be some resources for our citizens. And so that's often the analysis that I think tribal governments have to undertake. And so I would challenge those of us in the environmental movement to think about how we can come in, and what I've seen happen in some instances is amazing foundations working with solar energy companies going to these remote areas and reservations and saying, we're going to fund $3 million worth of solar energy panels that'll also create 60 jobs here on the Standing Rock Reservation. So now, Standing Rock can invest in renewable energies with the help of a foundation, create jobs for their citizens, and also now provide electricity to elders for free at no cost, which is amazing. So those kinds of partnerships, I think, are really exciting, and hopefully we'll see more of those.
I think this is kind of part of the environmental justice or climate justice question. You cannot tell the Yupik Eskimos in northern Alaska just to stop drilling and sit in the dark and give up their schools and roads and everything else. If you want to have environmental justice or climate justice, you have to have a just transition and fair solutions and offer some way to compensate people for keeping their forest in place, for not drilling. And so that's part of, I think, the environmental or climate justice aspect. I think we had time for one more question. Did you have a question?
Yeah, all of you have spoken about power dynamics at some point in your talks. Could you talk about the process of trying to build sustainable, trustworthy relationships with the people that you're negotiating with, and how that plays a role on your efforts to get where you're trying to go?
You know, I took my bag off here because I wanted to get access to my passport. And especially for what we face in the developing part of the world, a lot of what we go through is how transnational corporations have really captured our states. And I don't know for you here in the U.S. whether you have corporate capture. But I always say that I carry a passport that says I'm from the Republic of Liberia. Well, actually, I'm from the Republic of Exile. But they control our government. The executive, the legislature, the judiciary. They influence decisions because, like we said earlier on, the argument was the land and the resources are in the area where communities and indigenous people reside. It is a territory. They are poor, they are disenfranchised, and so the rich and the powerful use their influence to try to grab those resources. As a result, the entire state process is held captive. And the only interest that we build are corporate interests. So we're trying to negotiate. We pretend we want to be able to negotiate. And we bend backward underneath. But if it is not for profit, they won't find a way to negotiate until you make it extremely expensive for them. So in the case of us, for example, in the case of what a traditional lawyer would do, I spent years in rural villages, sleeping in swamps, organizing people, building the resistance, involving media campaign, going to court, trucking people from their towns and villages to the courthouse, sitting down trying to find a way to negotiate with the government, and most times influenced by these corporations. So it's difficult to understand that. And part of, I think what I see is the kind of economic, financial, or investment model that I see the whole world is besieged with, which is what we are all facing now. My belief that we have a way of life, we want to get everything else, we want to extract. But like I said, it's coming back. So climate change is no respect of borders. I was here last year when the hurricane hit a number of areas. Even here in New Orleans, it's going to come. So until we all realize that we are in this boat together to find a way to address that, it will be very difficult. And so those of us who are on the front line, like the activists and the defenders, we try to get the point, but we try to find a way to negotiate. And it's very difficult because a lot of the corporate decisions are moved by profit. And then when they hold the state captive, it's difficult to find a way to address those issues.
I think we're going to have to wrap up because we have another panel coming in here. I hope we can continue the discussion tonight, the reception. I want to thank our panelists so much.